Welcome to those of you that have joined. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join us before we start. Welcome to the Five Stone Buildings webinar program. We've just opened the live links. We're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for everybody to join, I shall just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of your screen, and our speaker will try to come to them at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And just to remind you that we now have a separate section on the Five Stone Buildings website where you can find a copy of this recording and any slide views and any previous webinars that have taken place. And I will now hand over to Simon Douglas.
Thank you, Jo. Well, welcome everybody to this Five Stone Buildings webinar. The topic for today is post-death arrangements, variations, disclaimers, and discretionary trusts. In essence, what I'm going to be discussing is changes made to a person's estate, whether it's a will or an intestacy or something else, using the statutory provisions under sections 142 and 144 of the Inheritance Tax Act, and similar provisions under the capital gains tax legislation. So I'm going to jump right in and talk about the value of section 142 and the ability to make post-death variations. So if we start with a very simple example, let's say that we have a testator who has died, leaving a specific asset, a plot of land that we'll call Whiteacre, to the original beneficiary. And let's say that the original beneficiary does not want Whiteacre in their estate. So what the original beneficiary might do is to make a gift of Whiteacre to a new beneficiary. Now, that gift might have all sorts of tax consequences for the original beneficiary. So for instance, if the original beneficiary fails to survive for 7 years, it will count as a failed pet. If the original beneficiary continues to live in Whiteacre after gifting it to the new beneficiary, they might fall within the gift with reservation of benefit rules. If the original beneficiary doesn't make a simple gift to the new beneficiary, but settles it on trust for the new beneficiary, then that transfer might be immediately chargeable to inheritance tax. And also, in gifting this property to the new beneficiary, there's likely to be a disposal for capital gains tax purposes, which again might incur a charge upon any post-death increases in value. So simply gifting an asset that you've received under a will can have quite penal tax consequences for you. What section 142 allows the original beneficiary to do is, to an extent, rewrites the testator's will. So instead of Whiteacre dropping into the original beneficiary's estate and then passing to the new beneficiary, Whiteacre, as a result of the section 142 variation, would be deemed as passing directly to the new beneficiary. And the benefit of that is you are, for tax purposes, cutting the original beneficiary out of the story. So the original beneficiary is no longer making transfers of value or disposals for CGT purposes. And that's why they're such a useful item to have in your toolkit, the ability to rearrange somebody's estate after their death. Before I go any further, though, I should say that it's important to bear in mind that what section 142 and the equivalent provisions in the capital gains tax legislation does is they simply deem a gift made by the original beneficiary to the new beneficiary to be effectively a rewriting of the testator's will. But that only happens for tax purposes. For all other purposes, we treat it for what it actually is, which is the original beneficiary making a gift to the new beneficiary. So, for instance, if the original beneficiary finds that they are liable for care home fees, then their gift of Whiteacre to the new beneficiary might be attacked under the capital deprivation rules. Or if the original beneficiary finds themselves as a defendant to a 1975 Act claim, then it might be that this gift of Whiteacre could be set aside under the Section 10 rule of the 1975 Act. And similarly, if the original beneficiary is bankrupt, then this rearrangement, this post-death rearrangement, might be seen as an attempt to avoid the original beneficiary's creditors. So you have to bear in mind that Section 142 only deems this to be a rewriting of the testator's will for tax purposes. For all other purposes, so in the real world, in effect, we see it for what it is, which is the original beneficiary making a gift to the new beneficiary. So Section 142 is a deeming rule. What are the requirements of Section 142? Well, first of all, the rearrangement of the testator's estate has to take place within 2 years of death. Importantly, that time limit runs from the testator's death, not from the grant of any of probate. Secondly, the rearrangement has to be made in writing. So this can't take place orally. I mean, query whether you could gift Whiteacre orally in any event. So it needs to be in writing. And that writing has to have something called a readback clause in it. So there's an example of a standard clause there. You simply say that you want the provisions of Section 142, and if you also want the equivalent provisions of the capital gains tax legislation to apply. Third, there has to be no external consideration, and I'll come back to that requirement in a moment. Fourth, the variation has to be genuine. Now, what does that mean? Well, it means two things. First of all, the variation has to change the destination of the asset. So in our example, Whiteacre goes from the original beneficiary to the new beneficiary, and in that sense, it's a genuine variation. Something that I've advised on a couple of times in the past is whether a gift of a specific asset to a residuary beneficiary can be rewritten as a specific gift in the will. And there's often tax reasons for doing that. And what I've said in the past is that that's probably not possible because you're not changing the destination of the asset. What you're effectively trying to do is to redraft the will. You're not changing the identity of the person who's going to receive the asset. So that's one sense in which the variation has to be genuine. The other sense in which it's got to be genuine is that you have to be changing the destination of an asset that actually belonged to the testator. In our example, Whiteacre actually belonged to the testator, and you're changing its direction from one beneficiary to another. But if Whiteacre never belonged to the testator, you can't, by a post-death variation, deem Whiteacre to have belonged to the testator and then vary its disposition under their will, because you're doing something which is not having any effect as a matter of general law, let alone tax. So the variation has to be a genuine one. Fifth, the variation has to be made by the beneficiary who is disposing of their interest under the estate. So it's the disposing beneficiary who makes the variation. So in our example, the original beneficiary is entitled to Whiteacre, so it's them who actually make the disposition. So it follows from that that the disposing beneficiary has to have capacity and can't be a minor. And finally, although this is not a substantive requirement, but a reporting requirement, if the variation results in more tax, then you have to report it within 6 months to the revenue. So those are the substantive requirements for a post-death variation under Section 142. Let me just say a few words about non-requirements, things that sometimes people think that you need to do, but actually you don't. So the first thing to say is, although I've been talking about a testator and a will, and I will do for the remainder of this talk, just to keep things simple. Section 142 is not limited to testators who die testate. It also applies to transfers by intestacy or survivorship. So if somebody dies without a will, you can rewrite the intestacy rules with a post-death variation. And equally, if somebody receives an asset through the rules of survivorship, so for instance, if somebody dies co-owning a house and that house passes to their surviving spouse through the survivorship rules, then you can also rewrite that under Section 142. So effectively, you can have a post-death severance of a joint tenancy. The revenue accept that you can do that under the wording of Section 142. Because what Section 142 says is that you can rewrite any post-mortem disposition, whether it's by will or otherwise, and otherwise includes survivorship. Second, do you need a deed to effect a post-death variation? Well, views on this differ. HMRC's position is that you don't, that any instrument in writing will suffice. If you look at leading text on this, lots of those say that you actually need a deed. And the reason that they say that you need a deed is that for the original beneficiary to actually dispose of their interest to a new beneficiary, there needs to be an execution of a valid deed. My view on this is, I think it depends upon what the parties are trying to do. So in most cases, I don't think that you need a deed, because what most beneficiaries are disposing of is an equitable interest in the estate. So the executors, or if administration has ended, the trustees, are holding estate assets upon trust for the beneficiary. And what that beneficiary is doing is disposing of their equitable interest in the estate to a new beneficiary. And if you're disposing of an equitable interest, then as a matter of general law, you can do that with simple writing. Whereas if what you've got is a legal interest, so for instance, if the asset has already been assented to you and you've got legal title to it, then you would need a deed in order to transfer your interest to a new beneficiary. So whether you need a deed or whether writing suffices, I think it depends upon what you're trying to do. Are you disposing of a legal interest or an equitable interest? To be on the safe side, it's always good to execute these things as a deed, but something that I've had to advise on in the past is where parties have not executed it as a deed properly, that they haven't, for instance, had the document witnessed. Third, the people who are receiving the assets under the trust don't need to be party to the instrument. So it's just the disposing beneficiary who needs to be party to it. So for instance, if you are disposing of gifts to a minor or to somebody who lacks capacity, you don't need to go to court to get approval for that. As long as the person who's making the disposition has reached majority and has capacity, that's fine. But note, if you are disposing of assets to a charity, which is something people frequently do in order to obtain the lower rate of inheritance tax, then you do need to notify the charity of it. And also note that personal representatives need to be joined as parties to the deed if they are if the deed of variation results in an increase in tax, because of course they're the parties who are going to be liable for it. But generally speaking, it's only the disposing beneficiary who needs to execute the variation. So if for instance, there's 10 people who benefit under a will, you don't need to join all 10 of them to the instrument. It's only the party who's disposing of an interest under it who needs to be a party to the deed. The final non-requirement to note is that the disposition you're effecting, it doesn't need to be one that the testator was capable of doing themselves during their lifetime. So a common example is where parties after the deceased death have established a new settlement and they want to know, can they execute a variation to redirect assets to that new settlement? Because of course that settlement was not something that existed during the testator's life. So therefore it wasn't a disposition that the testator was themselves capable of. And the answer to that is you can do that. As I mentioned before, these are all dispositions by a living beneficiary. That it's the living beneficiary who's making the gift or creating the trust. All that Section 142 is deeming it to have been made by the testator. So the fact that you can't do this, that the testator couldn't do that, is no bar to the beneficiaries under the estate from doing it. So let's look at some of the common uses of variations under Section 142. One common one is to rewrite old-fashioned wills that contain gifts of nil rate bands. So if you had somebody who's died before 2008, I think it is, when the transferable nil rate band was introduced, you might find that in their will, they've tried to preserve their nil rate band by making a gift of the nil rate sum to their child and the residue to their spouse. Those types of things can be a bit of a nuisance. So what you might want to do in that scenario is for the child to execute a variation, redirecting the nil rate sum to the surviving spouse. And that way you get the transferable nil rate band. Another common use of Section 142 variations is to rewrite wills so that they better utilize various exemptions from inheritance tax, such as BPR or APR. So a classic case is where a testator, A, leaves business assets to their spouse, B, and then the residue to their children, C. If you've got a will of that kind, what's happened is that the business property relief has been wasted because it's passing to a beneficiary who's already exempt. So what the beneficiary, the surviving spouse, would want to do in that scenario is to execute a deed of variation, redirecting those business assets to the children. And that way you preserve BPR. Although, just a note of caution here, if you are going to do that, be wary of the interaction rules under Section 39A. I won't go into any detail here about how they work, but in essence, if business assets fall into a gift of the residue, then the benefit of that exemption is not confined to the residuary beneficiaries, but is spread across the entire estate. So some of it would work its way back to the exempt beneficiaries, such as the spouse. So what you'd want to do in this scenario is not put the business assets as part of the residue going to the children, but actually create a specific legacy, a specific gift of those business assets. Another common usage of Section 142 is in order to avoid gifts with reservations of benefit. So, for example, if I commonly see this with holiday homes, family homes are a bit more complicated, but with holiday homes, you might have a couple, A and B, who co-own a holiday home as tenants in common. What happens is that when A dies, A leaves their half share of the holiday home to their spouse. What B wants to do is to reduce the value of their estate for HT purposes, so gifts that half share of the holiday home to their child C. But of course, if B continues to use the holiday home, then there's a risk that they'll fall within the gift with reservation of benefit rules. So a simple way of avoiding that is to gift the half share of the holiday home to the child through a Section 142 variation. So it would be deemed to have been made by A, and therefore B wouldn't reserve any benefit in it. A final common example of Section 142 is where they're used to settle 1975 Act claims. So if, for instance, you have two children and one receives the entire estate to the exclusion of the other child, and so therefore the other child, the excluded child, starts to bring a 1975 Act claim. If it's going to settle, a very simple and easy way of settling it is through a Section 142 variation. Some of you might wonder how that's possible given the rules on consideration. I can talk about that in a little bit, but in essence, HMRC, their practice, as I understand it, is not to challenge it upon that basis. So deeds of variation can be a simple way of wrapping up those types of claims, but their utility in that context can be a bit limited, because whenever the claim is going to affect the interests of a minor, well, at that point, you then need to start going to court to get approval for it. Okay, so as I've mentioned a couple of times, a deed of variation under Section 142 doesn't work if there is external consideration for the variation. So in essence, what a beneficiary can do is they can gift their share of the estate gratis, so they can give it away to a new beneficiary without receiving anything in return. Or if they do receive something in return, the thing that they're receiving in return has to derive from the same estate. If they get something in return which comes from outside of the estate, that would be considered consideration, and the read-back effect of Section 142 would not apply. It would just be deemed as a lifetime transaction. To give an example, where I sometimes see this is with balancing payments. So let's say that in our example, A has died, and in A's estate, you've got two properties, Whiteacre and Blackacre. And let's say that they slightly differ in value. So Blackacre is worth a bit more than Whiteacre. And what A does is A gives Whiteacre to one son, B, and Blackacre to a daughter, C. And what B and C decide to do is to swap them. So C wants Whiteacre and B wants Blackacre. Now, the problem from C's perspective is she's going to be giving up a property that's worth more than the property that she's receiving. So what C might reasonably ask B to do in that scenario is to make a balancing payment. So for instance, to pay £50,000 to C. Now, if C were to do that, the problem is you then have external consideration, because that £50,000 derives from outside of A's estate. So therefore, Section 142 wouldn't apply. That probably wouldn't have a huge consequence for IHT purposes, because in that scenario, it would probably be deemed as a commercial transaction rather than a transfer of value. But it can have problems from a CGT and an SDLT perspective. You might be paying any uplift in value. And what can be a real problem here is SDLT rules. They can work in quite a penal way, where what you're doing is you're swapping one property for another. You can effectively end up paying SDLT on both properties simultaneously. So external consideration can really cause problems in these scenarios. So you'd have to think carefully about how the parties could affect this swap. I mean, one thing I would think about here is, for instance, C gifting Blackacre to B, but charging Blackacre with a legacy of £50,000. So that £50,000, it would be charged upon the estate. So it would still be internal to the estate. Another common scenario to think about with external consideration is where you have informal arrangements to make payments to the original beneficiary. The revenue will look quite carefully into those arrangements. An example of that is the case of Lau against HMRC. What happened there is that you had a testator who left his entire estate to his children, thereby triggering a large amount of inheritance tax. And what the children did is they redirected their inheritance to the testator's estranged spouse. And therefore, it was an exempt transfer. But what the spouse then did is, over the following year, started to make large gifts to the children. And what the revenue said is that the gifts that the children were receiving was effectively consideration for the transfer that they'd made. So therefore, you didn't get the readback effect of Section 142. And a final practical point on consideration is think about who is going to be paying for the drafting of the deed. The position of the revenue is that if it's the new beneficiary, so the beneficiary who's receiving an asset under the deed of variation, if it's the new beneficiary who pays for the variation, then that counts as as consideration for the variation. And again, the Section 142 rules don't apply. So it's something you've got to approach with some care, or always make sure that it's the disposing beneficiary who pays for the drafting. Another issue that can arise with Section 142 is that of multiple variations. So often where parties affect a variation but then change their mind because it doesn't quite have the effect that they wanted. The rule is that when an asset under an estate is subject to a variation, then it can't be subject to any further variations. So if I receive Whiteacre under a will and I then gift it to a new beneficiary, if that new beneficiary were in turn to make another gift of it, that second gift could not count as a post-death variation under Section 142. It would just count as a pet. And that was decided in a case called Russell. If you find out that in the first variation you've made a mistake and you want to make another variation, what you have to do effectively is to either apply to rescind the original variation or to rectify it. And there's a number of cases where that's been attempted successfully. But whilst a particular asset can only be subject to a single variation, that doesn't mean to say that you can't have multiple variations of a will or an intestacy. It's just that each separate variation must be varying a separate asset. So if a will gives Blackacre to A and Whiteacre to B, A can have a variation of Whiteacre and B can have a separate variation of Blackacre. That's perfectly fine. And the other point to note about Section 142 variations is that they can be combined with an appointment out of a discretionary trust under Section 144. I'll talk about Section 144 in a moment, but just to preempt that with an example, let's say that A has died establishing a trust for the benefit of his daughter B, saying that B is going to get shares contingent upon her attaining the age of 25 and to accumulate until then. Let's say that B is currently 20. Let's also say that B is feeling a bit sorry for her brother C, who's not received anything under the will. What the trustees can do is they can decide to appoint to B outright. And if they do that, then the appointment will be read back into the will under Section 144. And B can then independently decide to redirect the shares to C under Section 142. So you can combine a Section 144 appointment with a Section 142 appointment. Be wary when you're doing that with the rules on frauds upon a power. So if this is a predetermined scheme, then there might be a challenge later down the line saying that the reason why the trustees appointed to B was to confer a benefit upon C. So just query whether you're going to fall foul of the fraud upon the power rules, but in this scenario, it's B's decision to do this, so it's fine. Double death variations. It's commonly the case that it's a beneficiary, a living beneficiary, who is disposing of an interest that they've received under a will or an intestacy. But what happens when that beneficiary has died? Can their personal representatives affect a variation? Because effectively you've got two deaths there. You've got the testator's death and the beneficiary's death. And you sometimes get this where what somebody's worried about is an asset being taxed as part of two estates. So an example here is, let's say that A dies in 2020 and leaves Whiteacre to B. And let's say that B then dies the following year, leaving Whiteacre to C. What happens there is that Whiteacre is being taxed twice over, once in A's estate and another time in Whiteacre's estate, in B's estate. There might be quick succession relief, but assuming that there's not, that leaves C in a difficult position because the asset that they've received is being taxed twice over. So what would be good for C is if Whiteacre passed directly from A to C. So the question is, can B's personal representatives, after B's death, affect a variation of Section 142, redirecting B's entitlement to Whiteacre directly to C? So instead of it going from A to B, then to C, it would go directly from A to C. There's not really clear guidance on this question. A position that the revenue might take here is they might say, well, it's not a genuine variation because C is going to benefit either way. You're not really redirecting an entitlement to C. My view is I think that this is possible. And the reason for that is that what is happening as a matter of law is that on A's death, the person who's entitled to Whiteacre is not C, but actually B's personal representatives. And they need to use Whiteacre for the administration of the estate. In practice, that's then going to benefit C as a beneficiary in the B's estate, but legally, the person who's entitled following A's death is not C, but rather it's B's personal representatives. So I think there is a genuine change in the destination of the property. It is going from one person, the personal representatives of B, to a new person, C. So I think that that works. I think that's fine. Be careful, however, where you have a life interest. So a slight change on the above facts. Let's say that what A leaves to B is not Whiteacre, but rather a life interest in Whiteacre, remainder to C. And what C wants to do is to get rid of B's life interest so that Whiteacre then just passes directly down. And in a case of suitor, the court said you can't do that because it's not a genuine variation. By the time that B has died, B's interest in Whiteacre has terminated because it's a life interest. So B's personal representatives have no interest in Whiteacre at all. So they have nothing that they can actually pass to C. You might be able to reach that outcome, but it wouldn't be by a variation, rather it would be by a disclaimer under section 93, which I'll touch upon in a moment. And a final point on variations, before I get to some other topics, is capital gains tax variations. You might recall before when I gave an example of a standard read back clause, it said that the parties didn't just want it to be read back for the purposes of section 142 of the Inheritance Tax Act, but also for the purposes of section 62 of the capital gains tax legislation. And the reason for that is that when the original beneficiary makes a gift of the asset to the new beneficiary, they are giving not just they're not just making a transfer of value, which they want to avoid, they're making a disposal for CGT purposes. And you want to avoid making a disposal for CGT purposes because then any increase in the value of the asset after death is going to trigger a charge for CGT. So if you read it back for CGT purposes, what it means is that the new beneficiary acquires the asset at its death value. What I would say about CGT readback clauses is that sometimes you don't want to include them because you want to utilize the disposing beneficiary's annual exemption. So for instance, if I've received Whiteacre and I want to make a gift of Whiteacre to a new beneficiary, and let's say that it's increased in value by £12,000, if I don't read it back for CGT purposes, then I'll utilize my annual exemption and the new beneficiary will acquire it at its current market value, not its death value. Disclaimers. There's not an awful lot to say about disclaimers. That you can also do them, that they're also governed by section 142. And the way a disclaimer works is, well, if you think about a variation, what you're doing is you're not just giving up your entitlement to an asset, you're actually dictating who you want that asset to go to. Whereas with a disclaimer, you're just giving it up. That's all that's happening. So what typically then happens is that that asset falls into the residue or on a partial intestacy. So if A leaves Whiteacre to B and then the residue to C, if B then disclaims Whiteacre, Whiteacre is then rerouted into the residue. And again, that would be a transfer of value, which could have all sorts of tax consequences for B, possibly. But you to be careful, you just avoid that by having a section 142 variation. So then you would treat Whiteacre as accruing to C automatically upon A's death. So I'm just going to correct myself. I said a moment ago that if B disclaims Whiteacre, it would be a transfer of value. Actually, I'm not sure if it would be that. I'd need to look into it. It depends upon this quite tricky case called Malice and Wilson, and it treats a variation. It's a bit like Schrodinger's cat. You treat it as never having existed. But anyway, I won't bore you with that. But anyway, so the Section 142 treats the variation as being read back, the disclaimer as being read back into the will. Section 142, it's got pretty much the same requirements as a variation. So it's got to be within 2 years and in writing for no consideration. But there's two exceptions. First of all, you don't need a readback clause. So a simple deed of disclaimer that makes no mention of Section 142 at all will suffice. And also, as a matter of general law, to disclaim an interest, you have to make sure that you've received no benefit, you've not accepted any benefit. So if B had started to live in Whiteacre or receive rents from Whiteacre, they would not be able to disclaim it under Section 142. Also bear in mind Section 93, which allows somebody to disclaim a life interest. I won't say anything about Section 93 because I dealt with it in some detail in an earlier webinar, which you can see online, where I looked at tax planning for personal representatives. And then the final topic, discretionary trusts. It's a bit of a misnomer, this, because Section 144 is not just concerned with discretionary trusts, although that's the most common example of a trust that falls within Section 144. It's to do with any case where you have settled property, where there's no qualifying interest in possession. So it can be discretionary trusts, but it's also often trusts where there's a contingent interest. So where asset is held on a contingency or in succession. And the basic requirements of Section 144, so it's where a person A has died, and immediately before their death, they had assets which are settled by their will. So A, for instance, establishes a discretionary trust in their will, but not, as I said, an interest in possession trust. And then within 2 years of their death, and before any interest in possession is created, an event occurs upon which you would normally charge an inheritance tax, upon which an inheritance tax charge would arise. Then two things happen. First of all, that IHT charge does not arise, and the disposition is read back into the will. Now, what does all of that mean? Well, effectively, if I create on my death a discretionary trust for instance, the benefit of my issue, and within 2 years of my death, the trustees appoint the assets in that discretionary trust to one of my issue, then that appointment, first of all, won't trigger a charge to inheritance tax, which it normally would do under the relevant property regime. And secondly, you would treat that disposition as being made in my will. So in other words, you would treat my will as if it made an outright gift to that particular beneficiary. Now, why would you use Section 144? Well, I think there's the most two common cases that I come across is, well, first of all, to get rid of unwanted nil rate band discretionary trusts. So if you come across a testator who's had an old-fashioned will containing a nil rate band discretionary trust, you often want to get rid of that so that the nil rate band just passes directly to the testator's surviving spouse. And that way you take advantage of the spousal exemption and also the transferable nil rate band. And the way you do that is that within 2 years, the trustees should appoint one of the assets in that nil rate band discretionary trust to the surviving spouse. That is an event upon which inheritance tax would normally be paid if it wasn't an exempt beneficiary. So therefore it's read back into the will. So you treat the will as never having created a nil rate band discretionary trust, and the assets just pass directly to the surviving spouse, who then gets the transferable nil rate band. A second context in which I often see Section 144 is where a will has created a trust which is going to start racking up relevant property charges. And what you want to do is to get rid of those relevant property charges before they arise. So let's say, and you often see this where a testator has created a trust for their grandchildren. So let's say a testator has created a trust for a minor who gets the income at 25 and then capital at 30. That's going to fall into a relevant property regime. So it's going to be subject to 10-year charges and so on. So what you might want to do is to get it out of that relevant property regime before it starts triggering charges. So what you could do is to appoint that asset to the minor, assuming you've got the powers to do so, either absolutely upon an interest in possession trust, and that gets it out of the relevant property regime because it's read back into the will, and that the beneficiary is treated as just having an absolute interest. So those are contexts in which you might want to think about using the Section 142